Have another bill.
Thank you. Yes, sir.
File item number 8, SB 322. And you may proceed when ready.
Thank you. I believe there was a single amendment suggested. I'm happy to take that. So, just to begin, the bill deals with admission and disciplinary policies at our public charter schools. And let me state from the outset, I am of the firm belief that we have some great charter schools in California. I know I have a number of them in my district. But we want to make them the very best that they can be. And at the same time, the U.S. Department of Education and the U.S. Department of Justice have raised some serious concerns with regard to both admission and disciplinary policies that this bill will address. So 322 ensures that charter schools, as part of the statewide public school system, have non-discriminatory admission policies as well as suspension and expulsion policies that guarantee students appropriate due process. So this is really about the civil rights of our students in our public charter schools. There have been some news stories in the past year that have indicated that there are mandatory parental volunteer hours at some of these schools, minimum English proficiencies, and a certain GPA for admission. These discriminatory policies harm students of color often and also students from low-income families. So the bill requires that any charter school admission policies, number one, be approved in a public hearing, also ensure students with disabilities, academically low-achieving students, English learners, and low-income students who are eligible for free and reduced price meals will be served, and also consistent with federal law and the California Constitution. And lastly, that they do not require mandatory parental volunteer hours as a criterion for admission or continued enrollment. And then the bill also addresses both school disciplinary policies and expulsion policies. Charter schools are exempted from following the existing statutory due process protections relating to the suspension and expulsion of students at public schools, and as a result, charter school students can be denied their right to due process. SB 322 ensures that all of California students receive appropriate due process at public schools by explicitly requiring basic due process protections the U.S. Supreme Court has said all public schools must provide, such as notice and opportunity to be heard. With the help of the committee, we have expanded the bill to include additional protections, such as the right to appeal. As I had mentioned earlier, the United States Department of Education and the United States Department of Justice have weighed in on both admission and disciplinary practices at charter schools, and they have urged states to ensure that the civil rights and due process rights of all students are protected. And I think it's time that California listen and take action. The mission of our public schools is, of course, to educate all of our children, and this bill reestablishes our commitment to that very mission. So, as amended, I would ask for your aye vote, and I have a number of witnesses here today.
Mr. Chair and members, Seth Bramble here on behalf of the California Teachers Association, proud to co-sponsor this important legislation. As this bill has moved through the legislative process, we heard an assertion from the California Charter Schools Association that the authorizer approves admission requirements and preferences and would reject things that were inappropriate. We have found widespread that not to be true, that there's a number of discriminatory admission requirements and preferences that we've seen in the state, and some of those examples were outlined by the senator here. One, in terms of requiring volunteer hours, public advocates put out a piece of research earlier this year where they looked at 500 schools. We're not talking about a school or two, and a third of those schools did have mandatory volunteer hour requirements. Now, That may not be a problem if you have two parents at home and one is available to provide time to volunteer in a school. But in a situation where, for example, grandma is acting as mom and dad and working two jobs, when they see the application that has a volunteer hour requirement, they set that application to the side. It's a deterrent, even seeing an application that has a requirement for volunteer hours. One specific example at Santiago Charter School, authorized by Orange Unified School District, there's a requirement of 12 service hours that parents are asked to state whether they're going to volunteer that time, or actually they fill out a form here, or will they donate money. Quote, for every $10 donated, you will receive 1 service hour credit. That's an example of the kind of discriminatory admission requirements and preferences we seek to eliminate. In some cases, some California charter schools had up to 30, 40 hours of required volunteer hour requirements per year for parents. I did pass out a number of examples to you members of the committee regarding some of these discriminatory admission requirements and preferences. Those were the result of kind of a quick Google search, so those are probably not the most problematic examples, those that maybe weren't posted online and that we don't know about. These kinds of preferences and admission criteria are becoming increasingly creative, discriminatory, and limit student access at charter schools. Charter schools are public schools that must be available to all students. We urge your I vote.
Thank you, Seth.
Good afternoon. Good afternoon. My name is Poonam Janeja, and I'm a staff attorney at Public Counsel Law Center. We represent thousands of the state's most vulnerable young people each year, including in disciplinary proceedings in both traditional and charter public schools. We have seen over and over the harms that these students suffer as a result of insufficient procedural protections at some charter schools. Under current law, these harms often include lengthy exclusion from the regular public schools as well, even though those students do not receive the same protections as if they had attended those schools. Timothy, one of our clients, was summarily expelled from a charter school when he was in the 8th grade. He was not even given an opportunity to be heard before he was expelled. The school's policy was to allow him to request a hearing only after the decision to expel him had already been made, and the school never even told him or his mother about this option. He could not get into a comprehensive school in his local district until the charter school agreed to clear his expulsion term. They refused to do so for more than 2 years, even though the expulsion was only supposed to last for 2 months in the first place. Lydia, a 5th grader at a charter school in LA who we also represent, was expelled after a family member placed marijuana among her school things without her knowledge. After it was reported to the principal, he immediately suspended and then referred her for expulsion without ever giving her a chance to explain. Then the school changed the time and the place of the expulsion hearing without providing notice to her or to her mother, so she missed the expulsion hearing completely. We've also seen countless students who have simply been told that they cannot return to their school without formal or informal procedures. This is not an isolated or unusual occurrence. One charter school in Oakland, for example, told more than 120 students, over 15% of its student body, last summer that they weren't allowed to return. SB 322 will help to protect these children. As the Supreme Court has recognized, exclusion from the educational process is a serious event in the life of a child, and it carries serious consequences for that student. The bill will require that public charter schools give students simple and fair procedural rights before they are deprived of this fundamental right. Thank you.
Good afternoon, Chair and committee members. My name is David Sapp. I'm the Director of Education Advocacy for the ACLU of California, which is a proud co-sponsor of this legislation. I'm here to answer any technical questions that the committee members may have.
Thank you. Others in support.
Ron Rapp, on behalf of the California Federation of Teachers, we are proud to be a co-sponsor of this important legislation as well, and respectfully urge an aye vote. Thank you.
I'm Ernie Silva from Sciatech, a public charter school whose mission is to re-engage dropouts, and we're one of the charter schools in support.
Thank you, Mr. Chair. Members, Mitch Seaman with the California Labor Federation, also in support.
Mr. Chairman and members, Dolores Duran Flores with the California School Employees Association. We're also co-sponsors. We don't believe that any public school in California should have any kind of discrimination admission policies, and we believe children should have strong due process rights before they're expelled or suspended. Thank you.
Mr. Chair and members, Erin Evans on behalf of the San Francisco Unified School District in support. Thank you.
Shireen Walter on behalf of California State PTA in support.
Liz Guillen with Public Advocates in support.
Any opposition?
There you go. Make room for Rand. Of course.
Mr. Chair and members, Rand Martin on behalf of the California Charter Schools Association. First, I want to make clear we're not here to talk about the preferences piece or the volunteer hours piece. We're comfortable with that language in the bill. We're only here to talk about the discipline piece. In 1992, when the Charter Schools Act was enacted, one of the central precepts of the law was that charter schools would be subject to a mega waiver of great swaths of code relative to the pedagogy, the delivery of the instruction, the operation. Ever since that time, in the ensuing 23 years, when there has been a problem that has been validated, we have all stepped forward and fixed it in the law to make sure that the problem did not continue. What we are lacking in this bill, unfortunately, is a demonstration of a problem. First, I need to make it very clear that despite some of the assertions by Senator Leno as well as the sponsors, we are governed under the law currently relative to due process. We must abide by due process, and we do. We also must abide by a discipline policy that includes expulsion and suspension that is vetted by our authorizer, approved by our authorizer, overseen by our authorizer, and if the authorizer finds that there's a problem, the authorizer has the authority to step in and either cure the situation or, if it's awful enough, to lead to the revocation of the charter school. We have a pretty heavy sword hanging over our heads to make sure that we do the right thing and that we comply with the discipline policy that we agreed to. The author also has mentioned reports out of U.S. Department of Education and U.S. Department of Justice, which on the surface sound like they are validation of a problem in California, but they're not. California charter schools have not demonstrated a problem in terms of suspending or expelling students at any greater rate than traditional public schools. And in fact, in the data that we're more easily able to get access to, which is the suspension data, we actually suspend at lower rates across all grade levels and across all demographic groups. I wish I could say the same for expulsion. The expulsion data is unfortunately heavily redacted, very difficult to get to, so it's harder to make that assertion. But we believe that suspension is probably a really good indication that that's the situation with expulsion as well. We have faced a lot of bills this year, last session, previous sessions, where we seek to re-regulate charter schools. If you're going to re-regulate us, demonstrate that there's a problem. Please demonstrate that there's a problem before we actually make these changes, because these changes have heavy-duty costs, both in terms of actually implementation and actual cost to us without a justification. We urge you to vote no. Thank you.
Thank you. The next witness.
Hello, Mr. Chair and committee members. My name is Alfonso Paz, and I am the co-founder and executive director of Apex Academy in Los Angeles. And I'm here today to urge a no vote on SB 322. Apex Academy is a conversion high school in Los Angeles with 460 students. 98% are Title I, 96% are Latino. Majority are first-generation immigrant families. 1/3 of my students are at high risk and already part of the criminal justice system. We welcome all students, and many come to Apex because they are low on credits and other schools have pushed them out. We are heavily focused on restorative justice, and our policy is never to expel students. Apex Academy has a higher tolerance than other schools for disciplinary issues. We create a contract for each student regarding their behavior and the expectations. When a student is moved, it is due to safety concerns. Examples of reasons why some students have disenrolled include gang issues or family issues. We have had some dismissals at Apex as well. One of the last dismissals we had was when a student set a fire and another student brandished a knife. What is unique about our school is that 60-70% of our students all return back to Apex, even the students who have left voluntarily. While Apex Academy never expels students, in the examples I have mentioned where students have been dismissed or disenrolled, SB 322 would require our school to treat dismissals and disenrollments the same as an expulsion and go through a very prescriptive and lengthy, costly process. Apex Academy would be required to provide educational programming to students for up to 80 days throughout the expulsion process, which we do not have the same resources at our disposal as district schools such as a continuation school. If SB 322 were to become law, the costs incurred by the charter schools to comply would come out of the classroom, as charter schools would be ineligible to be reimbursed with the new state mandate. For these reasons, I urge you to vote no on SB 322.
Thank you. Others in opposition?
Eric Premack with the Charter Schools Development Center, representing several hundred charter schools up and down the state. Many of our schools specialize in serving students who have been previously expelled or otherwise dropped out of traditional public schools and present often.
We've already had two witnesses in opposition. Do you want to summarize quickly?
No. Okay. You had several speakers in favor.
Okay.
I thought you might be balanced on that. I'm sorry.
Jennifer Wada, here today on behalf of Ed Voice, also opposed for the reasons stated.
Thank you. Others in opposition? Seeing no others in opposition, comments from the committee members? Mr. Thurman.
I just had a question for the last, next to last witness who was introducing himself, and if you were going to offer something that hadn't already been stated, was it something that you were getting across that we should know?
Yeah, many of the schools that we work with students who have been previously expelled from traditional schools, present serious disciplinary or other challenges for the schools. Many of them, we often are able to deal with them very effectively. But the provisions in this bill go way beyond providing due process. And we're very concerned that that will provide a disincentive for these schools to serve these kids going forward, in effect having the opposite of the intended effect of the bill. Thank you.
Thank you.
Mr. Chavez.
Senator Lano, thank you for bringing this issue up of suspension, because I think it's extremely important. You know, I was listening to your testimony, and there was a letter submitted by Superintendent of Instruction Torlakson on 29 January. And in his letter for 2012-2013, you know, there are according to his letter, 609,471 students in the state of California that were suspended. And I just find that is, man, that's a lot of young minds being kicked out of schools. What strikes me also in his letter that in African Americans, though in our schools they only make 6.2% of the population, their suspension rate is 16.2. 53,000 young African Americans, you know, denied an education. In the Hispanic community, there's 179,867 that were denied an education. So your issue that you're talking about, suspension, it's a huge problem. And Superintendent of Instruction Torlakson mentions that and talks about how he's working and improving that, and I applaud him for that. So I appreciate you bringing this forward. It's something that we need to do a lot more on. As far as charter schools, though, as you know, a charter school, a component of the charter itself actually deals with how you're going to handle disciplinary actions in the school. And that when the charter is put together, it'll list out all the different procedures, and it will also have to be approved by the authority, the local educational agency, the school district, on the disciplinary action. So those procedures are already in there. One who's operated a charter school, I can tell you many of the children that I had in my school were kids that were suspended from other comprehensive schools, and the only choice they had was at my charter school. I had well over 80% of minorities. A number of my children were non-citizens. And as far as special needs, I remember one mother bringing me a child who was homeschooled up until 9th grade, and because he had Asperger's. And when he first came to the school, he was, we had to have a special training for all the teachers how we're going to deal with this young man who you couldn't touch, you couldn't get in a corner, you had corrective actions, method of instruction, but all the teachers signed on for the training to figure out how we're going to do this. 3 years later, this young man was the president of the class, president of the school, and when he took his girlfriend to the prom, his mother was crying that she never thought that this young man would ever be socialized, but the charter school was able to give him that opportunity. In particular, the issue also had to do with the environment. And I speak to the environment. I see you smiling. But I speak to the environment this way. Charter schools have a unique environment to ensure all children are successful. And a component of that environment is the disciplinary, which is established by the charter. So there are a lot of successes in there in dealing with this issue of suspension, dealing with the issues of mental issues. And for those reasons, I will not be supporting this. If you want to deal with suspensions or opportunities, I'm all over that. But as far as due process, that's all part of the charter. It's all structured in there. And to me, this appears to be, you've identified a very good issue. I ran down the numbers why I believe it's a good issue. But charter schools aren't the problem. I will not be supporting your bill, sir.
Thank you, Assemblyman. Mr. Chair, could I make a brief response?
Yes, you may.
Thank you. Assemblyman Chavez, if all charter schools in California operated like the one that you operated, like the one that we just heard from, Apex Academy or Sciatech in San Francisco, which is here to support the bill, we wouldn't be here today. But that's unfortunately not the case. And I think your question actually gets to the core of why we are here. Unfortunately, the Charter School Association, I believe, is in denial. To deny that there's a problem, to actually say, nothing here, folks, don't look here, there's nothing here, is not going to allow us to address the very serious issue that you've identified. And so, if I could, I just want to share with you that in the association's original opposition letter to our bill some months ago, it attempted to cite UCLA Civil Rights Project's forthcoming report analyzing suspension and expulsion data at California charter schools to support their claim that there's no problem. The UCLA Civil Rights Project requested that the Charter School Association retract that initial oppositional letter because the letter made, in their words, an inaccurate and misleading reference to UCLA's forthcoming report on charter schools and school discipline. UCLA criticized the association's letter for inaccurately citing their project as the source for the finding that when traditional schools are compared to charters, there is no difference in suspension and expulsion. In their letter, they said that the association's, this is quote, the association's misleading references to our unpublished preliminary findings on charter schools for the express purpose of bolstering their opposition, your opposition to Senator Leno's proposal, which our research supports, is emblematic of the concerns raised with the inaccurate portrayal of charter schools by charter proponents. They go on to say, quote, to the contrary, our published research supports the proposed changes offered by SB 322.
And if I may respond to your comments,
of course, through the chair, please.
As you know, charter schools are reviewed every 5 years. If there's ever a problem with the charter school, you can revoke the charter. Unlike other public schools, which I'm sure we could play numbers, other comprehensive schools, you cannot revoke them because they're there. So charter schools have 5 years that they lose their charter if they're not doing what they want. And additionally, there's always an opportunity, even during that 5 years, if charter schools are abusing their charter, they can be called accountable on that. And the last issue is the California Charter School Association just recently put out a letter identifying, I believe it was 10 charter schools that they said should have their charters revoked. And as I've told them before in my office, they have a responsibility to police charter schools because I'm the first one to say I ran across charter schools that are there solely to make money and take advantage of children, and there's no place for them in California. And if you find them, I'm with you. I'll help you put a stake in their heart. But we should not paint everybody with the same brush. It doesn't work.
Thank you.